A confession. It's arguably the absolute most powerful piece of evidence you're going to see in any criminal trial. I mean, when an accused person actually admits their guilt, it feels like, boom, case closed, right? But hold on. What if that confession was literally beaten out of them? Or what if it was promised in exchange for some kind of leniency? In this explainer, we're going to trace the fascinating and honestly incredibly rigorous journey of a confession within Pakistani criminal law. What you see is a system intricately designed to balance the relentless pursuit of truth with some seriously powerful built-in safeguards against coercion, drawing on both the common law tradition and Islamic evidentiary principles.
So here is our roadmap for today. We're going to start by laying out the basic confession framework. Then we'll look at the absolute ban on police confessions, dive into threats, promises, and inducements, break down the magisterial exception, and finally, tackle what happens when confessions are retracted at trial. We're literally going to follow the physical journey of an accused person, starting from those incredibly vulnerable moments inside the police station, moving into the relative safety of a magistrate's chamber, and finally arriving at the trial court, where, as you'll see, confessions are often dramatically taken back.
All right, first up, let's establish exactly what we're talking about and lay down the foundational rules of this framework. In the eyes of the law, a confession isn't just you casually admitting you did something wrong. It is a very specific statement made by an accused person admitting all essential elements of the offense charged, the whole shebang. It's the most direct form of evidence of guilt you can possibly get. But, and this is a massive but, because it's so direct, it is highly susceptible to fabrication and coercion. Because of that exact risk, the Qanun-e-Shahadat order, which we'll call the QSO, and the Code of Criminal Procedure, the CrPC, create a very strictly constructed legal framework to handle them. That brings us to the very first stop in any criminal investigation, the police station. Notice the stark contrast we have here. On one side, Article 26 of the QSO is crystal clear. It dictates that no confession made to a police officer shall be proved against an accused person, period. This is an absolute bar. There is absolutely no voluntariness exception here. Even if the accused spontaneously walks up and confesses to a police officer of their own free will, it's totally inadmissible. And Article 27 adds that confessions made while in police custody are also generally inadmissible. You can't just bypass this rule by repeating the confession to another officer. Now, on the other side of things, we see the only legal path forward, the magisterial exception under Section 164 of the CrPC, which we're going to dig into shortly. Think about why the law has to be so rigid here. This Supreme Court ruling in the State v. Hazor Bosch illustrates it perfectly. The court confirmed that the bar under Article 26 is absolute and admits of zero exceptions. The core rationale? It's the protection of the accused. The court recognized that the inherent coercive power the police hold over someone in custody makes trying to assess voluntariness completely unreliable. Therefore, a confession made to police, no matter how wildly detailed or apparently genuine it sounds, simply cannot be used as evidence of guilt.
But look, coercion isn't always physical, right? Which takes us into the realm of psychological manipulation. This specific framework applies to confessions generally. Article 38 of the QSO mandates 4 specific elements to completely exclude a confession. First off, there has to be an inducement, threat, or promise held out to the accused. Second, it has to have reference to the charge, meaning it relates directly to the criminal proceedings at hand. Third, it has to proceed from a person in authority, like a police officer or a magistrate. And fourth, it must be sufficient to give the accused reasonable grounds for supposing that by confessing, they would gain some kind of advantage or avoid a temporal evil regarding the proceedings. If all 4 of these are present, boom, the confession is excluded.
So how on earth does a judge actually measure that 4th element? In Mohammed Nawaz v. The State, the Supreme Court laid down a really fascinating subjective test. The court ruled that inducement must be assessed from the perspective of the accused, not some hypothetical objective observer. The judge literally has to step into the shoes of the accused person, considering their specific characteristics and their exact circumstances in that very moment. They have to ask, would this specific person have felt that confessing would bring an advantage or an escape from evil? If the answer is yes, the confession is thrown out, regardless of whether it actually influenced their decision.
Okay, having established what invalidates a confession, let's move forward in our journey. The accused has now left police custody and is brought before a magistrate. This right here is the only legally viable route for an admissible confession.
Now, before we look at the strict procedure a magistrate has to follow, it's super important to understand how Article 40 of the QSO handles some, well, unorthodox conditions. If a confession is otherwise relevant and admissible, it doesn't automatically get tossed out just because of weird circumstances. For example, if it was made under a promise of secrecy or through deception, or surprisingly, even if the accused was flat out drunk. It also survives if it was made in answer to questions the accused didn't actually have to answer, or without an explicit warning. However, keep in mind, this only covers general relevance. It still has to survive the intense recording procedure we're about to cover.
And that intense scrutiny happens right here. Section 164 of the CrPC outlines a strict, step-by-step procedure for the magistrate. Step 1, they have to actively warn the accused that they are not bound to confess and that if they do, it may be used against them. Step 2, verify the statement is entirely voluntary. Step 3, ensure they are fully aware of their rights and absolutely aren't acting under police pressure. Step 4 is critical. Give the accused adequate time to reflect. Ordinarily, the confession should not be recorded the exact same day they arrive from police custody. Finally, Step 5, the confession is meticulously recorded, read back to them, and signed.
So how seriously do the courts take this checklist? Honestly, very. In Mohammed Ayub Khan v. the State, the Supreme Court declared that these procedural safeguards are mandatory and substantive. What does that actually mean for us? It means failing to strictly observe any single one of these safeguards renders the entire confession utterly inadmissible. It's not a guideline, it is an all-or-nothing procedure.
And here is perhaps the most critical mandate from that ruling, especially concerning physical coercion. If an accused appears before the magistrate and shows visible signs of torture, or even just complains of mistreatment, the magistrate is legally bound to immediately record this fact. And, crucially, they must halt the confession process entirely. They literally must not proceed. A confession recorded in the face of visible signs of torture is wholly inadmissible, for sure, even if the magistrate formally complied with all the other procedural steps we just talked about.
Which brings us to the final and, honestly, often the most complex stage of this journey, the trial itself. Months, sometimes years later, the trial begins. And at this stage, it is incredibly common for the accused to suddenly just disown the confession they previously made to the magistrate. When an accused retracts their confession, the trial court is faced with a really difficult puzzle. Are they looking at a voluntary truth that the accused is now just trying to escape? Or is it a coerced fabrication they are finally brave enough to expose? Well, in Manzoor Ahmed v. the State, the Supreme Court provided the test for this. The trial court must logically weigh the conditions under which the original confession was recorded against the circumstances surrounding the current retraction, to see which scenario is actually more likely.
Through years of case law, some really clear principles have emerged here. First off, a retracted confession isn't just automatically thrown in the trash. Its evidentiary value is simply weighed. If it's deemed reliable, it can be used to corroborate other evidence. However, a retracted confession, standing completely on its own, is ordinarily insufficient to sustain a conviction in a capital case. You're almost always going to need independent corroboration when a person's life is on the line. Furthermore, if the accused retracts the confession and provides a highly credible account of exactly how it was obtained, like detailing specific torture or threats, and that's supported by other evidence, the confession is given zero weight.
To put all of this into perspective and see how it plays out practically, let's look at the case of Rafiq, who was charged with murder. Chronologically, here's what happens. Step 1. Rafiq is brought in for a Section 164 recording. He makes a highly detailed confession describing the weapon and the circumstances perfectly. The medical examination notes absolutely zero injuries on him. Step 2. Fast forward to the trial, and Rafiq retracts his confession. He now claims he was beaten for 3 days straight and insists he told the magistrate about it but was ignored. Step 3. The trial court steps in to assess this conflict. They look at the magistrate's sworn deposition stating Rafiq made no such complaint. They look at the medical report showing zero injuries, and they see that the confession is completely consistent with the forensic evidence. Then they compare all of that rock-solid evidence against Rafiq's new, vague trial account.
Because the court methodically weighed those original Section 164 safeguards against the weak retraction, the final outcome here is pretty clear. The court finds Rafiq's retraction incredible. The original confession is accepted as reliable evidence. This perfectly demonstrates how the entire system relies on those initial procedural safeguards holding up under intense scrutiny. When the magistrate does their job perfectly, ensuring there's no torture, giving them adequate reflection time, and properly warning the accused, it creates a foundation that is very, very difficult for a fabricated retraction to dismantle later on.
So we've followed the entire journey, from that absolute bar on police statements, right through the subjective test for inducements, all those meticulous procedural safeguards required of a magistrate, all the way down to the intense balancing act a trial court has to perform when a confession is suddenly retracted. Looking at this whole system of absolute bars and mandatory safeguards, it leaves us with one crucial final question to consider. Does this rigid framework successfully balance the relentless pursuit of the truth with the fundamental protection of the accused?